Good evening. This is Laws 12062, Alternative Dispute Resolution. We're into week 7 and we're dealing with other dispute resolution processes. There's a whole range of processes, including collaborative law and partnering and others. So I'm going to start with collaborative law. We have some people online, and firstly I'll invite anyone to give me their thoughts in relation to what collaborative law is all about. Does anyone wish to make any comments? All right, just a quick overview. Collaborative law, in a sense, started with family lawyers. It's cynically, perhaps, a means of competing with FDR as an alternative dispute resolution procedure. And it was commenced in the family law jurisdiction where lawyers were perhaps fearful of losing some work to FDR, which didn't necessarily involve the presence of lawyers. So it's essentially informal conferencing or roundtable discussions with a bit of a twist. It's mediation, if you like, without a mediator. And it's one step more formal than mediation in the sense that you have lawyers on both sides, whereas that's possible in mediation but not necessary in mediation. So in that way, it's a little more formal than mediation because the dispute is taken away from the parties. And here's the important part. The collaborative agreement provides that in the event of the matter not resolving, then the parties will essentially walk away from the dispute. The lawyers will walk away from the dispute and they won't become involved in litigation. The rationale behind it is that it promotes cooperative work between the lawyers to have the matter resolved without litigation. I must say, from my observations, it doesn't seem to be well established or highly used. Spencer, in his commentary, talks about it being a paradigm shift from adversarial to cooperative practice from lawyers, and in that way, you can see that many of the steps and the processes, the aims are very similar to mediation. So for that reason, it can be very closely aligned to mediation, but as I said, it's almost mediation without a mediator. There is one thing though, the process can include an extra person called a coach, and that coach can assist the parties in coming to a resolution because the lawyers are not co-mediators. Now, if we introduce a coach, perhaps you could tell me what you think we're looking at, because it's starting to look very much like mediation. Are there any... now, Margaret says it's where the parties and their lawyers meet to look at disputes in a collaborative way, and I do like this approach. I could see myself working in this framework. Yes? And I might be a little cynical with it, Margaret. I appreciate that. Now, does anyone else wish to add any comments in relation to collaborative law?
Well, again, it's trying to keep the cost down. It's trying to get away from the cost and stress and length of time that normal courtroom litigation takes. It's offering an alternative, which can work in the right circumstances in the right industries. For instance, partnerships and commercial contracts, construction industry, that sort of thing.
Yes. All right. Thank you, John. Could I share this with you? It's a quote from Ardagh and Cumes. It's the legal profession post, ADR, from mediation to collaborative law. And it's a part of an article from 2007, 18 Australasian Dispute Resolution Journal at 205. The commentators, Ardagh and Cumes, say, collaborative law is a process without mediators, and it seems to have arisen in response to the competition from mediators, particularly in the family law area, and to other changing legislative demands. Whether or not this is a positive development is questionable, given that similar ADR services may be found elsewhere more cheaply. Collaborative law sessions require 4 to 7 sessions. The rise of collaborative law since these amendments, that is the 2006 amendments to the Family Law Act requiring compulsory ADR processes, leaves open the suggestion that lawyers are creating another dispute resolution process, one which they control. Collaborative law is being promoted at a time that family law is excluding lawyers as the primary dispute resolution practitioners. It raises real questions about whether or not it is genuine ADR reform or just an alternative to institutionalised ADR. So if we want perhaps the more cynical view of collaborative law, perhaps that's it. My personal view is that collaborative law in a form has been around for a long time. We would always call it informal discussions or roundtable conferences. But as I said, the real kicker with this one is the commitment from the lawyers to withdraw if their aims at resolving the matter through negotiation is unsuccessful. It's almost a bit like the no-win, no-fee concept. If we can't get this thing settled, we won't trouble you anymore. So I think there's some pros and some cons. Margaret says, I also like the way that it educates community members in how they approach and resolve disputes. So I think that's very good too. Can you think of any other ways in which collaborative law might be advantageous to parties? And I'm thinking particularly where there are special circumstances, where the parties have special circumstances. Do you think collaborative law can help as opposed to, say, mediation? If I could pose one, in the family law area where we have children, if the parties can speak to each other civilly enough for a period of time, then maybe it does make sense, as soon as they have their lawyers engaged, to save the time period and the formalities of getting mediation underway. If there's a dispute that requires resolution this weekend, maybe collaborative law is a way to go, because it can be so quickly implemented, much quicker than mediation, I would have thought. Anyway, think about that. That's just one example that comes to my mind. All right, are we happy to move on? Dispute resolution advisors. Would anyone like to give me an overview of what this process is all about? Dispute resolution advisors.
Well, it probably started off in 1991 in Hong Kong with, I think it was the Queen Mary Hospital, was it not?
Yes.
Where until then they had with major government contracts a lot of problems, a lot of disputes, and they had tenders for this major work. And it was going to be quite a problem because they wished to keep the hospital open whilst the work was going on. They had asbestos problems as well. And so they brought in as dispute resolution advisor, and he worked extremely well. They had something like 750 items of sort of possible argument, and yet the work was completed successfully. And it's gone on from there and it's spread. Okay.
Thank you, John. That's excellent. Thank you. Would anyone else like to add anything in relation to dispute resolution advisors? Would someone like to give me an overview? So John has identified where it began correctly in Hong Kong with that particular project. How does it come into being? Margaret says basically it's about preventing disputes before they blow out of proportion, and it can be part of the contract. Now that's interesting. You've raised a couple of very valid points there. The first is preventing disputes before they blow out or blow out of proportion. Now, is that a little different to standard ADR principles, trying to prevent a dispute before it blows out or before it comes into existence? How does that differ from, say, mediation as a form of ADR?
Well, mediation, either voluntary or court-ordered, only comes into place when a problem has been identified that needs to be resolved.
Exactly. So yourself and Margaret have correctly identified the preemptive nature of the dispute resolution advisor regime. Margaret also says it can be part of the contract. Now, that phrase suggests a few things in itself, doesn't it? Correctly, in relation to dispute resolution advisors. Firstly, it presupposes that we're talking about some sort of commercial regime or commercial situation, as opposed to collaborative law, which started in family law. Well, we're not going to have a contract between the parties. I I hope, well, we might, but we wouldn't necessarily have a contract between parents before the child is born about what they do in the event of a dispute. So dispute resolution advisors presupposes perhaps a commercial arrangement. And can I suggest probably a relatively sophisticated commercial arrangement? If we go back to John's point, it was talking all about that major contract in Hong Kong, the Queen Mary Hospital. Margaret says industrial relations would be another area where it could take place. That's an excellent point. Industrial relations, I think, would be an ideal situation to consider introducing dispute resolution advisors. Any other thoughts where we could use this? What its overview? How it differs from others?
What I thought was most interesting with the dispute resolution advisors was how they can design and implement training schemes within organisations to equip stakeholders with the necessary dispute handling skills. Is that something a mediator would do? But, yeah, I thought that was interesting.
Look, and I think that's an excellent point, Catherine. What you've done is you've identified the preemptive nature, but you've gone one step further and you've said, this is how, it's all very well to say, let's introduce it into the contract. But what you've said is, let's introduce it into the contract in a commercial situation. And here's the mechanism that can create the existence of the dispute resolution advisor, or here's the preemptive nature of the work that can be done by the dispute resolution advisor. So that's excellent. Thank you. Thank you for that contribution. Could I add a couple of other things? So it's often at pre-contract level, it's often commercial, it's often in relation to sophisticated clients. The dispute resolution advisor would usually be someone who has technical skills. It's aimed at having an on-the-spot resolution. And this is an important aspect. It's a recognition from the outset that the appointment is because we are going to collectively accept the problems that occur and we will collectively work towards a resolution of these problems. It's a pre-commitment in that sense. And it provides for a quick resolution mechanism to be put in place. So we've got the history. We know it was in Hong Kong. It's developed from there. As Spencer said at page 133, stakeholders are encouraged to think about the problems in the project as being our problem as opposed to your problem or my problem. The contract is signed, and in figure 5.1 on page 134, Spencer provides a dispute resolution advisor flowchart, which might be part of that contract. So in that instance, if there's a failure to resolve, then the matter can go on from there. So can I just pose this to you, that in a way, the concept of dispute resolution advisors is not strictly ADR because of the preemptive nature, and it might better be described as a dispute avoidance process as opposed to an alternative dispute resolution process. Does anyone wish to make any comments about that proposition?
Just that it's probably a better way to go to prevent things rather than take care of them when they've arisen, rather like crime prevention.
Precisely. And can you picture this in a commercial context? If, as a result of doing this course or studying law, you choose to become an ADR practitioner, people will say, oh yes, you're a mediator. And I think we've identified through this course, and particularly tonight, there are just so many different avenues of ADR that you could be very busy in a whole range of areas very quickly by applying thoughts as to how this could work in a more practical sense. Now, can I just take you back to a chart which was in Spencer's book at page 2, right back to page 2, and it's the first diagram in the book, figure 1.1, and it's a a reference to the degree of informality, involvement, consensuality, and intervention of the various dispute resolution processes. And you'll see that number one being the most informal, most consensual, and non-interventionist is good old-fashioned negotiation. Now, dispute advisors or dispute resolution boards are number 4. So they're right up in that corner, which is informal. Now, there's 14 of those, number 1 being negotiation, 14 being arbitration, which is the most court-like. So it may be a useful exercise, and I've done this, so I'll let you know as we go, just to identify that number between 1 and 14, just so you've got a visual link to put in context where this is. So collaborative law was 8 out of 14, mediation is 7, which is right in the middle, and the one we've just done, dispute resolution advisors, is 3 out of 14. So it's at the informals end of it. Now, Margaret has said, I thought that alternative resolution of a potential dispute would be a way of including it in ADR. I wouldn't argue against you there, Margaret. It's certainly part of the alternative dispute resolution course, and it's still ADR. I'd agree with you there. It's probably maybe we can dual categorise it as a dispute avoidance process as well as an alternative dispute resolution process. How does that sound as a compromise? Is that okay? All right. Thank you. Let's move on to dispute resolution boards, which is 4. Dispute resolution advisors is 3 out of 14. Dispute resolution boards is 4 out of 14, meaning it's still quite informal. Anyone wish to add any comments as to dispute resolution boards? Where do they fit in? What does that mean? Someone give me an overview.
They're generally set up at a pre-contractual stage.
Yes. So similar to dispute resolution advisors in that sense. Would you agree?
Yes, very similar. Or they can be appointed by the parties once they actually have a final contract and they know that the project is going to go ahead.
Okay, very good. So why would you, do you think, appoint a dispute review board as opposed to a dispute resolution advisor? Anyone got any thoughts?
The main difference is that each party would have one person on the board and then there will be a neutral.
Excellent suggestion. And a couple of advantages there. Of course, the fact that you've got 3 helps to break the deadlock. 1 from each side means you've got representation and advocacy. It sounds like a plan, doesn't it, having a dispute resolution board? The fact that it's a pre-contractual matter, and I agree with you entirely there, John, what does that tell us about the nature of the dispute which it is attempting to deal with?
Well, it hasn't arisen yet, but they may think that because it's a complex project, there is going to be at least one area of contention which will need an in-place resolution mechanism to deal with, to avoid the project overrunning on cost or simply ceasing.
Thank you. Yes, I entirely agree with that. And Margaret has said perhaps it may be associated with the more formal field, commercial, probably contracts of high-level companies, and the people associated with the board are likely to have technical expertise. I agree entirely with all that. So I guess we're getting a flavour for this as well, aren't we? Whereas collaborative law was kind of family law-ish, dispute resolution advisors more in terms of commercial, contractual, high-end dispute. I think dispute review boards are much the same as well. We're talking about, once again, a dispute avoidance process. It's pre-contractual, so we've correctly identified that. And it does take advantage, as Margaret has correctly identified, of people with technical skills. What else? If the board is called upon to intervene in a project, how do you see it working? How do you see it panning out? What would the board do? What's its role?
Well, I see their main role as trying to stop problems getting larger and getting into intractable situations where there's downtime, workers walking off the job, all this sort of thing.
Yes. So it's quick resolution. It's almost, you could almost say, on the spot resolution, isn't it? Because when you're talking about workers working off the, walking off site, we're talking a lot of speed and also big money, big ticket problems associated with issues that might arise. So I think in the construction industry where we've got people involved, I agree with you there, John. Technical issues, I would see the board as meeting on a regular basis. And Margaret has quite rightly identified the cost of using dispute resolution boards is minimal as opposed to litigation or delays on the project due to strikes, etc. Absolutely. Having 3 of them helps to prevent deadlocks. The board meets regularly, provides everyone an opportunity for input. So a lot of advantages. So if you were a commercial lawyer drafting commercial contracts, even though you're not, let's say you're not an ADR practitioner, that knowledge of what a review board is all about would be very valuable, wouldn't it, in drafting the contract? All right, well, let's move on. The next one is partnering. Now, when we talk in terms of the rank between 1 and 14, partnering's right up in that top right-hand corner. It's number 2 out of 14. It sits right next to negotiation, and it's in between negotiation and dispute advisors. So it's right at that informal, consensual, non-interventionist end. So would someone like to give me some quick overview of partnering? What's it all about? Why would we have partnering? What's the concept all about?
Having read...
Again, it seems to be businesses, since they talk about stakeholders coming together to communicate effectively and work as a team. Okay.
Absolutely. Thank you very much. So again, it's sort of that commercial aspect, that cooperative aspect. Thank you, Catherine. John, is there anything you wanted to add to that?
Just that if you get all the stakeholders to adopt it and think that this project is ours, its success is ours, its failure is ours, not that that bit's yours and this bit's mine and that's your fault and it isn't mine, it will generally work a lot more smoothly and, dare I say, cheaply.
Yes. So there's a lot of planning involved in this as well, isn't there? From the outset. And I'm just looking to Moodle because there was an excellent response put on there as well earlier this week. All right, I'll just move on. So partnering, once again, a dispute avoidance process. It's essentially pre-contractual. It's part of the planning. It's still ADR, but it's less formal than a dispute resolution board. It's not something which has been set up between the parties. It tends to be for the parties. Margaret says, partnering, it's the buzzword within the government and NGO sector, and it's joining resources and goals to achieve a higher aim or outcome. Thank you very much for that. So it is often at the pre-contract level, often facilitated by charter, says John. It takes advantage of in-house advisors with technical skills. So it's more in-house, I think, partnering than between the groups, but there is the parties do develop the charter. It's almost like good old-fashioned, let's trust each other, let's reduce it to writing, let's go into this with good faith. It's a bit like a sophisticated handshake, don't you think, partnering? The parties are adopting a cooperative culture of mutual trust. So let's talk about the specifics of partnering. What do we need to do to get partnering to work? Thank you. Margaret's got some comments that she has provided me with. So while I'm looking for that, does anyone like to add some comments about how partnering would work in practice? Margaret has said, partnering is coming together of stakeholders to work as a team.
You'd also come together to work out what your major aims and objectives were and how to achieve them.
Yes, absolutely. Parties make a commitment to each other to listen, to learn, to question, to engage, to achieve the desired outcome. Thank you, Margaret. Dispute prevention is the goal, but parties learn valuable skills as they go: reflective practice, diversity of views, cultural protocols and patterns, getting to know each other in a much more sophisticated sense. I like that perspective, Margaret. Thank you. Let's talk about some specifics. I think with partnering, one thing you could consider is undertaking a workshop, even before the part of the project starts. Now, the same might apply to the Dispute Resolution Board or the Dispute Advisors, but partnering has that, I hate to say it, sort of more that touchy-feely team effort feel about it than others. So partnering may be a workshop. And in that workshop, set up an agenda. Consider a location, appoint a leader or facilitator, and introduce some team building exercises. In the course of doing that, try to identify the interests of the parties. You know, the word interests comes up a lot in ADR. And it really is, when we remember when we were talking about mediation, we were talking about identify the interests as opposed to the position. Well, in partnering, maybe during a workshop, we're able to do that right at the start. Try and work out what are the interests of the parties. Identify the issues of concerns, and in advance, try to work out likely ways of resolving that. And then, as John indicated, arrange for the drawing of the charter. Now, what would we put in the charter? What's that all about? Anyone like to offer a suggestion? What would you put in this charter as part of the partnering process?
Well, how problems, if they arose, should be brought to the attention of all concerned, how they should be dealt with, whether weekly, fortnightly, monthly, or wherever, that sort of thing would go in the charter.
Absolutely, yes. So setting out some ground rules for communication as well. And you'd need to review that process, I think, on a regular basis, wouldn't you? Maybe identifying in general sense the mission statement. Okay. I'm sorry I'm distracted. I'm looking for something which I can't find quickly, but we'll find it soon. All right, anything else on partnering? Margaret has said, mapping of particular issues that can bring out issues as well. And that's true. By going through this process, the parties are likely to discover things, the objectives and the goals of the stakeholders, not excluding others, timeframes, protocols, etc. So it really is very heavy in terms of resources at the front end of the project. And that's why it's so much towards the top of that paradigm, as opposed to arbitration and litigation at the opposite end. Okay, let's talk about appraisals. Who would like to tell me something about appraisals? Give me an overview of what's the appraisal regime all about? Any comments?
Appraisals are where the dispute resolution practitioner, the case appraiser, investigates the dispute which has already begun and provides advice on it and its possible and desirable outcomes and means by which these might be achieved.
Okay. Thank you very much, Catherine. Excellent. So it's really an advice type arrangement. It's relatively informal in that sense, generally undertaken by an expert in the industry, generally not binding. Any other things any other characteristics? I think Catherine's pretty much got them all though. Usually non-binding, says John. Thank you.
Usually undertaken by an expert in the particular field of the dispute.
Yes. Now, what type of expert? I just want to make, I'd like to draw your attention, well, I'd like you to think about, when we talk about an expert, what type of expert are we talking? Just in a general sense.
Someone who's familiar with the industry in which the appraisal is taking place.
Yes, an industry expert. Thank you, John. The reason I make that comment is that later we'll talk about lawyers being introduced as the expert, not necessarily involved in the industry. Appraisers generally don't have to comply with the rules of natural justice. There's sometimes no necessity for them to provide a written reason for their reasoning or for their conclusion, and generally suggest a desirable outcome to the parties who are free to accept or reject. So that's appraisal. And why is appraisal different to the next topic, which is early determination? Anyone think about that?
A case appraisal is generally not binding, while a determination will be.
Absolutely correct. Yes, thank you. Any other comments in relation to the difference between expert determination and appraisal? No? Okay. So it's binding. It's once again an industry expert. So when we're talking industry expert with all of these, there's a real commercial flavour to it, isn't there? I don't know about you, but I always think about construction issues when I'm talking about early determination or appraisals, even partnering. I mean, maybe I need some guidance here on what type of disputes these things can be used in, because my mind keeps coming back to construction industry or family law. There's a whole lot of other disputes, aren't there? What other areas of dispute would be appropriate for appraisal or expert determination? When we talk about an industry expert, what industry? No one?
It could possibly work on a union basis in demarcation disputes.
Absolutely. I think Margaret identified that it might be useful in industrial relations as well. So thank you. All right. Early determination, it's number 10 out of the 14, so it's quite formal. It is binding. We've identified that. Industry expert, yes. Relatively informal, not governed by legislation. No rules of natural justice apply. No need for a written decision. And like many of the others in this whole regime, there is an important thing, and that is that the decision remains private. And that could be very important for a company, a construction company, or for an organisation where reputation is important. They'll want these things to remain private. A large construction company may not want the market to become jittery if it appears that it is unable to resolve construction issues in relation to large-scale projects. I'm just suggesting ideas here, but that's probably an important consideration. Let's move on. Early neutral evaluation. What's all that about? What's early neutral evaluation? Any thoughts?
Well, just where in the early stage of a dispute the participants agree to have an expert called in to try and help with the resolution of it.
Okay, thank you. What sort of expert?
Probably a former judge, barrister, that sort of thing.
Okay.
Someone involved with law and logic.
Yes. Now it's at the more formal end. It's getting close to the arbitration end, the litigation end, the mini trial situation. You know, down that bottom left-hand corner of that graph, the lawyers really take over, don't they? And expert determination is in that category. Look, it's not a determination by an industry expert. We're kind of past that. We're now at the stage of saying, well, we're going to get serious about litigation, but before we do, let's take this dispute, which is substantial, to someone who is at the level of the person or people that will ultimately make the decision if we go through the whole cost and stress of litigation. So let's get an ex-judge, or let's get a QC. Let's get someone who is legally trained and well regarded to effectively provide us with a snapshot of what we're likely to get if we go on. So Margaret says it's non-binding, yes, and a senior legal background experience, correct, as John identified. So again, there's no rules of natural justice. It's relatively informal in that it's not governed by legislation. There's no need for a written reason, but one would expect a written reason. The decision remains private, but it has that sobering effect. Could you imagine the effect on your client if you're advising in a commercial litigation dispute where a recently retired judge comes to the conclusion that you're probably going to lose the case? Strong incentive to settle and get on with it. All right, speaking of courts, what is a court-appointed referee? Now, this is 13 out of 14 on the scale, so we're right down the left-hand bottom corner. The lawyers are going to be heavily involved now in referencing out. So what's referencing out all about? Any thoughts? No one wish to offer any suggestions? What's referencing out?
Referencing out, the referee is usually an expert in the area of the matter which is in question, and the court asks them to decide the matter as their experts, I guess, and they will hand down a report and provide the legal reasoning behind their decision.
Excellent, Catherine. Thank you. That's great. So the way I interpret it, it's part of the litigation process. The court determines that the referee should be appointed, as Catherine identified. The referee comes back with a decision, which is not binding, but it's open for the parties to agree with it or challenge it. And that is all or some of the findings. But that's not the end of it, because then the court ultimately decides whether to adopt it, to vary it, or reject it. All of it or part of it. And Margaret has correctly identified that referring to an expert party with expertise, confirming what Catherine said, it assists the court who may not have this level of technical expertise. And it does have legislative backing, and in that regard, Even though the text, I think, refers to the Supreme Court Act, that's been repealed. It's now the Civil Proceedings Act of 2011, and also referred to the Uniform Civil Procedure Rules of 1999. All right, we're getting close. Adjudication. What's adjudication? Any thoughts?
Well, it's generally restricted to the building and construction industry currently.
Yes. Absolutely. We have adjudicators in the building industry under the Building and Construction Industry Payments Act, 2004. Margaret says, any dispute about payments for goods and services? Where we often see it in practice is in relation to contractor and subcontractor disputes. It provides a relatively quick, painless resolution, and it does have power conferred upon the adjudicator by legislation. All right. Any other questions or comments? So it's quite a specific process.
Just one thing, that if the process isn't brought to a successful conclusion and the subcontractor gets his payment plus, if necessary, interest, work can then stop. He's not then breaking the law if he's gone through the correct procedure.
Absolutely. Yes. Thank you for raising that. That's a very important point. Okay. Let's move on to the final topic, which is resolution in criminal law matters. How does ADR work in practice in criminal justice? Would anyone like to give a thought as to how this might work?
Well, the typical scenario will be a victim and possibly a senior police officer and the offender in a room, and the victim gives an impact statement, and the offender would generally have to be acknowledging that they were guilty of the offence, and they sort out between the two of them probably a sentence or some punishment. The idea being that if the offender realises what he's done, he's less likely to reoffend in the same way, and it's likely to give some closure to the victim.
Yes, absolutely. Margaret makes the point. It's to do with restorative justice, allowing the victim and the offender to come face to face. I'm just going to mention a few things, and that is, it's not widely used in practice, but it is important in practice. Margaret says, instead of a faceless and nameless crime, the offender can see the results of their actions, and that's really important. Do you think that there's a particular group of offenders where the restorative justice regime may have greater impact than in relation to a different group of offenders? Young offenders, says Margaret. Absolutely correct. And it has been used particularly with young offenders, absolutely. So we call them youth justice conferences, typically. The rules in relation to youth justice conferencing have changed fairly recently. It's still available as a technique directly from police referral to youth justice conference. And it used to be available from the court as a sentencing option, but it's no longer available as a court-referred option. And the way it works for youth justice conferencing is that the young offender, supported by a parent typically, does meet literally in a room, in a circle of chairs. The victim is there, the police officer is there, someone from youth justice will be there as well, and sometimes a lawyer is there to represent the interests of the young person. However, the convener of the Youth Justice Conference likes us to remain as much as possible mute, because it's not a court and they don't like us arguing in that jurisdiction. So ultimately, I see our role as lawyers in a Youth Justice Conference to ensure that what the young person agrees to by way of self-punishment is appropriate, because my unfortunate observation with many youth justice conferences is that people just want much more than a court would ever order if the matter went to court. So, for example, a particular crime might warrant the imposition of 40 hours of unpaid community service. If they're starting to talk about doing 100 hours of unpaid community service, it might be an opportunity for me to quietly have a word with a young person and say, that's too much. Don't get too excited about it. All right, so that's youth justice conferencing, and that's conferencing generally, where we have the victim meeting with the offender in a sort of regime with the police, etc. What other type of criminal law resolution is available as an alternative to litigation? So we've done victim conferencing. What else is there? I'll mention two. Circle sentencing, yes. We used to have the Murray courts, which were very effective, but they've now been removed. I'm not sure ideological or monetary constraints, but we no longer have the Murray courts, which assisted in the sentencing process for Aboriginal and Torres Strait Islander defendants, where members of the Indigenous community would join in the process of sentencing. It's very effective. It's a pity it's gone, but it's no longer available to us. Another one is mediations. Now, it might seem odd that we talk about mediation in the context of criminal law, but it's available. It's not available throughout the state. It's not available, for example, in Hervey Bay, but it is part of the process set up by the dispute resolution centres in those areas which deal with it. So the dispute resolution centres are the government agencies or semi-government agencies which provide very valuable expert mediation services very cheaply for members of the community. And there are specially trained mediators that deal with mediation disputes in criminal law. Now, why on earth would the police agree? I mean, I can understand perhaps, thinking as a police officer here, why you might send a young person off to youth justice conferencing. Come on, young fella, let's face the victim, and you'll see what impact you have. Now, why would a police officer ever agree to mediation between adults? Can anyone come up with any ideas?
Well, one of the reasons would be you'd be hoping that the offender wouldn't re-offend, and if he didn't, then it would save the state a lot of money, because putting people in jail costs a fortune.
Absolutely. Okay, so there's some really good public policy issues there, an emphasis on rehabilitation, and also pragmatic, the cost associated with the criminal law litigation, the cost associated with the incarceration. And heck, if what we're really trying to achieve is a balance between a punishment and rehabilitation, well, on some occasions it may be more valuable to emphasise rehabilitation. And maybe what better way to do that than have a mediation session? What if you have a dispute between elderly neighbours over whatever it might be? Would that be good for criminal law mediation? Well, if I was
I'd imagine it would be, because if they're neighbours, they're going to go on living next to each other for quite a while unless one sells up or moves. Yes. It will be an excellent scenario to calm everything down and normalise relations.
Absolutely. And I think you've identified a very important point there. What you've said, well, there's that ongoing proximity. So, look, let's not worry about this common assault matter too much. Let's just make sure that these people that have lived as neighbours for 50 years, and suddenly started warring with each other, can actually sit down and talk it through, and maybe that'll be a better outcome for the community, rather than just going through the criminal law process. So maybe neighbours, elderly neighbours. Who else do you think would be candidates for criminal law mediation. Family members, two brothers, out for a night out, best of mates, get into a scuffle, the police arrive, they charge one of them with assault occasioning bodily harm. The next day they walk into the police station and the brother who was the victim says, mate, I don't want to press charges. He's my brother. We just had a night out. We got vigorous, but we're both over it. Please don't charge him. The police say, no, he's committed a criminal offence. We're pursuing assault occasioning bodily harm. Maybe that's a good one to send off to mediation as well. They're not living next to each other. Yeah, sorry, John.
Sorry, would not the police withdraw the charge anyway because they've just lost their main witness?
Well, not necessarily, because the decision to prosecute or not is not up to the victim. It's up to the police. It's up to the prosecutor. And they may say, we've got enough evidence even without you participating. We've got 4 witnesses who saw exactly what happened, and we've got CCTV footage, and we've got hospital records. So even without the victim giving evidence, we've got enough to secure a conviction.
Thank you.
No, anyway, if I was acting for the person in that situation, I'd be pushing hard for mediation for all those reasons. And Margaret's made some good points. Could be used to reduce the time and demands on police having to continually chase after menial offences. That's another good reason to send off for mediation. Could be can't teach an old dog new tricks, probably in reference to the scenario where we've got elderly neighbours. So apart from youth justice conferencing, which might work for young offenders sitting around in a table, round in a circle, we've got the older ones, maybe because they're neighbours or maybe because they're related, send them off to criminal law mediation. Another way to deal with things is maybe through the use of undertakings. So, all right, well, look, we're thinking about charging you with stalking. She says she just doesn't want you anywhere near her. She doesn't want to press charges. She doesn't want to go through court process. So instead of charging you with stalking, let's get an undertaking from you that you will stay away. Now, that's going to be an enforceable undertaking. We'll somehow try and get that into the court process. If it's on the court record, we won't go ahead with the charge of stalking. That might be another way of doing things as well. Sorry, your internet's playing up, Catherine. So undertakings may be useful for stalking, for domestic violence, things of that nature. All right, so just finally, if you're interested, I'll try and place the cue. There's a really good video on crime prevention in Victoria, and it relates to how the authorities dealt with a situation where young people were involved in the activity of parkour. You know, that free running, just jumping over buildings and sliding down balustrades, etc. One way to deal with that is to say, well, you're all trespassers and we're going to convict the lot of you and put you all in jail. Another way is to say, well, look, this is really a very healthy activity. It's a wonderful sport is another way of looking at it. Kind of dangerous, but it's we can understand the excitement and the athleticism, etc. So what they did was they effectively had a mediation session between people in town and the people that were doing the parkour, and they kind of worked it out. And what a wonderful resolution. Graffiti offences maybe as well, says Margaret. I happen to really like graffiti, and we're in the process of building, and we're going to put some graffiti inside our house. We're going to get some from Melbourne, put it up as artwork. So, yeah, there are different ways of resolving these sorts of issues. All right, look, I'm sorry it's taken a long time tonight. Are there any closing comments before I wrap up and just talk about next week? All right, thank you. Next week, I have in mind to have a discussion about where we're going in this course. It won't be so much out of the textbook, but I'd like to hear from as many people as possible. How are you going? What are the difficulties? What do you need to help you to get through this course? Are you having problems in partnering up? Have you done your Zoom session? Have you got any technical issues? So just a real, almost like a session about where we're at and where we need to go. And that'll be for next week, as well as some small component in relation to Chapter 6, I believe, for next week. All right, so thanks for your participation and all the very best.